Good morning, everybody. We are here today to give a brief overview of some HR nightmares on this Halloween day. We are looking at this as a reminder of some of the things that you should be doing at year end and to start with the beginning of the year, that, to revamp some policies and consider new and different things. And to look at some of the commonly asked questions that you might be getting over the course of the winter when we have a change in weather, and perhaps some changes in policies that might result in employees having additional questions. So let's begin. Okay, so the first issue that we have, the first scary story, as we're going to call these today, relates to telecommuting. And with telecommuting, we have a lot of different issues. First, let's talk about it as a job perk. Sometimes individuals would want, unrelated to any disability or any medically or legally protected area, they might ask you to work from home. And that job perk might seem to be something that an employer would want to provide, or maybe would have a very strong distaste for providing. If you do enter into a telecommuting arrangement with an employee, we highly recommend that you provide an agreement with that employee. This is outside of any accommodation that might be required under the Americans with Disabilities Act. This is just a job perk. That agreement should set forth the expectations of the employer and the employee, what will be done, what days or hours are permitted to work off-site, and handle a lot of other different things that we'll talk about in this particular section as well. More often than not, this will come about when we're dealing with the Americans with Disabilities Act, and an employee would say that as part of my accommodation, I'm requesting to work from home. Now, one of the things that we're going to have to evaluate when we determine whether this accommodation would be reasonable is, what are this employee's job duties? What does the job description say about the employee's duties? Obviously, your receptionist is not going to be able to work from home because he or she would not be able to greet your customers, or your clients would not be able to answer the phones from home. That's an easy one, but other positions might not be quite so easy. So the first place to start would be your job description. Hopefully that's an up-to-date job description and not a 20-year-old or 10-year-old or even 5-year-old job description. It's a good idea to review those every year so that when these issues come up, we have something that's up to date. So if you'd notice that in a particular position had duties added or taken away from it over the course of the prior year or 2 years, it's good to update your job description so that when you're faced with whether working from home is a reasonable accommodation, you have the most up-to-date information in front of you, and more importantly, a document that could be used if you were ever called upon to defend your actions in litigation. So this is a good time, I think, to review or make a note that part of your homework would be to review your job descriptions for accuracy. And if we're talking about issues, if you notice within your office environment that working from home, whether it be a job perk or something that people are asking for a reasonable accommodation, is something that is becoming more frequent, it's a good idea to determine what positions would be suitable for working from home. There's nothing wrong with, and in fact, it is a good practice to include in your job description, if a position requires presence in the office, to put that in your job description as an essential function. I'll talk about that in a few minutes, but that's certainly one of the things that we would advise for those positions that it would never be reasonable for them to work out of the office. So one of the things that we're going to look into next is what considerations beyond the ADA and beyond perhaps a job perk would you want to consider when you're discussing a telecommuting situation. I do also want to note that when we are talking about telecommuting, it is not something that is offered to a person who's on FMLA. While this might be obvious to some, you would be surprised some of the questions we get both from employees and some employers regarding the FMLA. If you're on FMLA leave, you are completely relieved from all duties whatsoever. So if you are working from home or telecommuting as an accommodation per se of a medical issue, you're not on FMLA. So I don't want anyone to confuse those two terms and to offer a telecommuting situation to someone who's on FMLA, because those two things are not consistent with each other. But let's look at some of the other considerations outside of perhaps getting sued that you might want to consider when either putting together a telecommuting agreement or having a discussion with an employee for purposes of telecommuting. The first thing, as with all aspects of the employment relationship, is we have to remember and be able to keep accurate employment records. And that includes our timekeeping. So what is the mechanism by which your employee who is telecommuting going to be able to keep his or her time? Do you have a time clock? Do you have a login system on a computer? Do you have a way to track the time so that you, as the employer, are not being taken advantage of by the employee, and the employee feels comfortable that he or she is going to be paid appropriately? So how do you track your time, and how can we do that with respect to a telecommuting employee? We want to make sure that these employees who are telecommuting are trustworthy, that they aren't going to falsify records or fudge their records if falsify is too harsh of a word. And we want to make sure that we feel that it's a beneficial relationship for both the employer and the employee. Are there measurables? Are there measurable deliverables that we can determine? You know, a report that is generated or logs of telephone calls that are made. How are we going to determine whether this person is actually doing their job away from site and doing it to our expectations? Those types of things, I think, should also be included in any agreement you draft for a telecommuter. I think an agreement is essential. I think that will outline duties and expectations, and more importantly, it will state that at any time, for any reason, the employer can revoke the telecommuting arrangement, as long as it's not an ADA issue, because you obviously cannot revoke a reasonable accommodation at your whim. But if you're talking about a job perk, having a provision in there that it can be changed at any time for any reason, I think would be essential. We also need to take into account that our non-exempt employees, those that we generally pay by the hour, when they work at home, they're still entitled to rest and meal breaks. Now, that might seem obvious to some that, of course, if you're working at home, you have the opportunity to take a break whenever you want. But you would be surprised how these situations come to fruition. And so you would want to remind your employee and put a provision in your agreement that it will be expected that they take their rest and meal breaks, and the meal break being completely relieved from duty as otherwise required by law, as if they were working within your environment as well. And obviously, the biggest issue for employers is going to relate to overtime. Whatever rules you have within the office about overtime and getting pre-approval for overtime should also be reinforced and reminded to the employee who's telecommuting, and that you've got to find a way to feel comfortable if this employee does work overtime from home, that you're not getting taken advantage of. All right, so there's some other issues that we may not have thought about when we're talking about telecommuting. So the first thing is workers' compensation insurance. So what happens if an employee is injured at home while telecommuting? Some things that you may not have considered. The first thing that I would suggest you do is, if you have someone who is on a telecommuting arrangement, whether it be for purposes of a reasonable accommodation or as a job perk, that you consult with your adjuster for your workers' compensation policy to determine whether that is protected or covered. Another issue is, does your employee live in a different state? Here in Louisville, we're very close to Indiana, and there are other cities throughout our state that are on state borders. I think we border somewhere 7 or 10 different states. And so is your employee going to work in a different state while your home office might be here in Kentucky? And so those types of things should also be considered and asked of your workers' compensation carrier. Another question that comes up regarding telecommuting is OSHA compliance and other risk management. Now, OSHA does not require employers to inspect a home office for purposes of workplace safety. So that is certainly something that is a good thing for the employer. But you might want to discuss and address in a telecommuting agreement the employee having sufficient homeowners insurance for a job-related or job-related injury, working while on the clock. because a homeowner's insurance may or may not cover it. We would want to make sure that everyone is sufficiently protected. Now, if hazardous materials are in use, which I don't think would necessarily be a common risk for anyone, that would be something that you would want to ensure that telecommuters comply with all safety rules, and that would certainly be addressed in your telecommuting agreement. The other thing that I think would be essential is to consider what sort of confidential information or proprietary information you have in this home office, or your employee has in this home office, that could be viewed by visitors or other family members. What if these visitors are employed by your biggest competitor? What if your employee's best friend is your biggest competitor? How are they going to safeguard your materials at home? Are there sufficient passwords on the computers? Are there ways to maintain your documents, materials in a locked area, just as you would within your job site? And so we would want to make sure also that if you're in the medical profession, that any HIPAA protected information is sufficiently guarded while in the home workspace. Those types of things need to be addressed in a telecommuting agreement and directly with the employee, and how your information will be safeguarded and protected. And also, if your employee is going to use their own personal home computer, your materials could therefore be on your employee's home computer. And so at the end of that relationship, whether the employee is fired or voluntarily resigns, you're going to want to be able to get that information back. I would highly recommend, obviously, that no home computers are used, but I've seen situations where that is the case, and we would have to treat that with some special care to make sure we get all of our information back. A couple of other miscellaneous issues when we're talking about telecommuting. What about tax issues across city, county, or state borders? There could be additional taxes if someone lives in one city and works in another. If there's a local tax, or if it's a different state, for example, then we're going to want to communicate with the employee that his or her paycheck may change. That is something that you would not want to get a surprise when you open your paycheck that it is less due to additional taxes taken out. You also, as the employer, wouldn't want to ignore this tax issue, and having been audited, I'll find yourself having to owe city, county, or state taxes because of a telecommuting issue. So that's certainly something you would want to discuss with your CPA for those individuals who telecommute outside of the city in which your home office resides. I talked a little bit about your intellectual property rights and security, that you're going to want to maintain that even in a home office, that no third party will be able to access accidentally or otherwise your confidential information. And finally, just on the employment discrimination side, you want to make sure that if you're offering a telecommuting arrangement to someone, that it's offered in a non-discriminatory manner, that no employee is preferred because of a protected reason in a telecommuting arrangement. And so it seems pretty common sense, but there are always things to consider when we are changing the employment relationship in any way. All right, so a couple of other things with regard to telecommuting requests. And this is specifically going to relate to your duties and responsibilities under the ADA. So telecommuting can be a reasonable accommodation. However, the court, the Sixth Circuit specifically, has addressed this in a very detailed opinion, the EEOC versus Ford Motor Company case. And I won't go necessarily into the details of that case during this particular seminar, but I will summarize it for you. One of the things that the Sixth Circuit said was that a job description that is drafted by the employer is going to be very persuasive with respect to whether on-site presence is an essential function of the job. That is the reason why at the beginning of this, I reminded you to review those job descriptions and to take note of whether that would be an essential function so that you could use it in particular in a litigation scenario. The other thing the court said, which I thought was very instructive, was that the existence of technology is not self-evident that telecommuting will be a reasonable accommodation. And that is because even though we all have access to our phones that maybe can connect directly to our email or even client port or employer portals, that doesn't necessarily mean that the job can be performed reasonably from an off-site location. There are certainly other things to consider. One of the things that the court addressed was the need to be present for impromptu meetings or access to documents. I think we can all imagine a scenario where you walk down the hall and you need to speak with someone and they're not there, and we get frustrated. We throw our hands in the air and the person's not there. And while that might seem to be a common scenario, there are some jobs where on-site presence is absolutely necessary. And the fact that I can pick up the phone and call or send an email or text will not be sufficient to make that telecommuting a reasonable accommodation depending on the nature of the job. So this case is very instructive. It provides, in a 20-page opinion, a lot of descriptive words and guidelines for us to use in drafting these job descriptions so that we can best come up with whether or not a position would be susceptible to telecommuting on a reasonable accommodation. All right, so let's go to our next issue. Our next scary story today relates to compensation for non-exempt employees. And just for some of you, we use the word non-exempt, and some of you will use hourly synonymous with non-exempt. And while that is generally the way a non-exempt employee is paid, we refer to it as non-exempt because that's what the statute and regulation, how it is defined under the statute and regulations. But I can tell you, I get as many questions about how to pay non-exempt or even exempt employees as I do ADA or other discrimination issues. I think there are several different problems that arise, or at least complications that arise when paying for certain scenarios. So we've identified the three most common headaches or nightmares, I guess, on this Halloween day when we're talking about compensation for non-exempt employees in specific scenarios. The first is going to be travel time. How do we compensate for travel time? Do we compensate for travel time? The second is going to be related to off the work-related emails or communications off the clock or outside of normal work hours. And the last is going to be a payment of or compensation for non-exempt employees when attending training courses with regard to either the business itself or employee improvement. So let's start with the first one. The first one is travel time. This is the regulation. The regulation states, as an enforcement policy, the divisions will not consider as work time that time spent in travel away from home, outside regular working hours, as a passenger on an airplane, train, boat, bus, or automobile. Whole bunch of words that don't necessarily mean anything until you get into the details of the regulations. And travel time is the one that makes me want to pull my hair out the most, because there are different rules for passengers and drivers and working travel overnight versus travel during the day. And so generally, I want to alert you to some of the general guidelines on compensation for travel time. So the travel time is not compensable. You do not have to pay an employee to travel when the travel is overnight outside of normal working hours. So what does that mean? So I'm going to give you an example. You've got an employee whose normal work hours are from 9 to 5, Monday through Friday, and they're going to travel at 6 p.m. on Saturday. Well, that 6 p.m. travel time is outside of those, quote, normal working hours, which are 9 to 5, because it doesn't matter what day of the week the travel occurs. It's only the hours that are the normal work hours of the employee. So if the employee travels from 6 p.m. to 10 p.m. on Saturday evening, that would not be compensable time. If the employee traveled from 9 a.m. to 1 p.m. on Saturday morning, then that would be compensable travel time. So the first thing you determine is, what are the normal work hours of the employee? Now, some of you may say, well, I've got employees that work odd hours or abnormal hours. It's going to be a more difficult question, but I think that we can probably sit down and work through what the, quote, normal work hours would be. So once you determine what the normal work hours are, regardless of the day of the week, then determine what time the employee will be traveling. If it's within those normal work hours, you're going to pay him or her for it, and if it's outside, you will not. That is the standard sort of simple rule. Now, that also means that if the employee is traveling as a passenger, for example, on a train or a plane, or a bus that he or she is not performing work. So if you have an employee who is traveling outside these normal work hours, but is working on a report or performing other duties for you, that will certainly be compensable time. So you might want to have that communication with the employee about what is expected during the hours of travel. I would also communicate with the employee what time will be compensable and what won't be, because I'm going to guess that your non-exempt employees are going to believe that if they travel for you, they should be paid, and that is not necessarily the case. So to avoid that that communication issue, I would go ahead and have that conversation ahead of time. Now, there are also different rules if the person is a driver versus a passenger. A driver is always going to be compensated if the employee is driving for you, no matter what the day of the week or hour of the day is. And the final rule that I've actually had to deal with in a couple of different scenarios this year is that the employer offered to fly the employee to another state for a conference. And the employee decided that he or she preferred to drive for one reason or another. The difference in travel time was significant between the flight and the drive. And so the employee was wondering what would be compensable. And the short answer is only the shortest amount of time. If you offer to put someone on a plane and that plane ride is 2 hours, but the drive is 6 hours, they're only going to get compensated for 2 hours of travel time because the employee chose to go a longer and different route. So those types of things are the issues that come up. And I say I pull my hair out because it seems like every scenario tweaks it a little bit and changes the rule. All right, other issues with regard to travel time. Travel during one-day assignments within another city is going to be compensable time. What we were just talking about is overnight travel. But when we are dealing with one-day assignments within the city, those are going to be, or outside the city, are going to be paid compensable time. And like I just said, any driving done at the direction of the employer is paid unless the employee has the option to use another form and chooses to drive instead. So travel time gets a little complicated and hairy, but we have a couple of different charts and summaries that we can provide to you as a desk reference that shows what's compensable and what's not. If you are interested in that, let me know. All right, this is the easiest one of the whole morning. And so let's look at it. While I say it's easy, you would be surprised how many times it's violated. So obviously, if you've got a non-exempt employee, then they're not supposed to work off the clock. If they do and they're not paid, then there are substantial penalties, which could also include attorney fees under both the state and federal law. Now, how does this come into play? How do you say, Cindy, does this happen? And more often than not, and that you get issues. One, a supervisor is either going to be not paying attention or not care. So the first step is to determine what your supervisors are asking the employees to do. Are they answering emails or text messages outside of work hours? Are they taking a business call from a supervisor, a client, a customer outside of work hours? Do they walk out and unload a truck or load a truck to help you out after they've already clocked out? Do they do, or are they asked to do paperwork after their shift is over or clean up after their shift is over? Any work, any one of these things would be work on behalf of the employer, even if you don't request it. We have had clients who have the best employees. They're very dedicated to their job. They know they're not supposed to work overtime. And so they clock out and then they do some of these things. Well, I'll just finish up this paperwork, or I'll help unload this truck, or I'll refill the refrigerator with the Cokes for tomorrow. All of that is compensable time, even if it is not requested by you. And even if it's done so at the initiative of a very diligent worker. Those are the types of things that we cannot allow to happen, because what does happen is at some point the employment relationship becomes disgruntled, or the employee becomes disgruntled, and all of these things now become your problem. Well, I had to do this, I did that, I spent this many hours a week doing paperwork and I was never paid for it, and they take it straight to the Department of Labor or the Kentucky Labor Cabinet, and now you have an issue on your hand. So we must express that all of this work would be compensable. We cannot allow our employees to do it on their own, even those diligent employees who don't want you to necessarily have to pay them for that, because I've seen it happen where they just feel that this is something that they can just clock out and do real quick, but it ends up being several minutes a day, maybe even hours a week, that they are not being compensated. So what do? We make sure that we have clear policies about it. We have communication reminders periodically, meetings or memos or bulletins that we send out to employees. We train our supervisors and managers to please not communicate with your hourly employees while off the clock. And we make sure that we limit access to technology. We do not want our non-exempt employees to have their work email on their phone. It's too easy to address work. I may leave here today, this evening, after my assistant is gone, and send her an email for something to do tomorrow. She might look at it and say, oh, I can do that right now, even though she's off the clock, or she might take steps to do it. And at that point, she is working and should be compensated for it. And if she doesn't turn those hours or minutes in, then we are violating the law, even though I wasn't intending on her to perform work outside of work hours. If she has access to it on her phone, and if she is someone who is a very diligent individual, and if she decides on her own to start working on it, then you would have to pay her for it. And we don't want that to get out of control. So we want to make sure our employees are not staying late or keep working if they're off the clock. We want to make sure they're not clocking out and then cleaning up a conference room or restocking the fridge or tidying up a workstation. All of those things we want to make sure are done on the clock. Oftentimes we get questions about employees who want to work through lunch. And can we allow them to do that? They want to do it. It is their choice. Why can't we let them do it? The general rule is they're not allowed to work through lunch, that they're entitled to the break, and they should take the break. What we need to do is, if we are looking to allow someone to work through lunch, is have a written agreement where the employee knows that she is or he is entitled to that lunch break, that we're not taking it away in any way, shape, or form, and that if they choose to do so, they can work through lunch. We do not want it to become a habit. We do not want it to become something where the employees get into that habit and all of a sudden, when the relationship sours, they say, you know what, they always made me work through lunch. And now again, it becomes your problem. So that's why we have to take our precautions on the front end about having these things in writing and making sure that the off the clock work isn't happening. I would say that working through lunch often happens in industries where you're dealing directly with a customer or a patient. You can imagine in a doctor's office or a service industry where people are constantly coming in, that it might be easy, or it might be preferred by an employee just to work through lunch and perhaps leave an hour early. In those scenarios, we definitely have to make sure that it's documented in the appropriate way so that everyone understands what their rights and their obligations are, and that they're not being taken advantage of on either end. I mean, this goes without saying, but it's part of my job to remind you that you should never ask a non-exempt employee to work off the clock. Most of what I just talked about is when employees do it on their own, but there are also scenarios when they're asked to do so. Supervisors should be reminded constantly not to ask their non-exempt employees to answer emails, text messages, or phone calls outside of work hours. And if they do, then we have to find a mechanism to keep track of that time. So the supervisor should remind the employee, and the employee should turn in time for the answering of the text message or phone call, so that you can protect yourself. If a supervisor has a habit or tendency or needs to contact your non-exempt employee outside of those work hours, make sure you find a way to make sure that that time is captured and paid. All right, so the last of these three scenarios is training time. And again, this is one that comes up in a variety of different ways, because sometimes doesn't fit the cookie cutter type of training. When we institute a new computer program, we have a lunch and learn. All employees come in, they get free lunch, and obviously that's paid. That's an easy one. When you have a new employee, they go through orientation. Obviously that's paid. But there's other training time that isn't quite so obvious. So the regulation that we've put forth here has certain criteria. If met, you would not have to compensate your employee. So the first is that the attendance in the training is outside the regular working hours of the employee. The attendance is voluntary, and that the course, lecture, or meeting is not directly related to the employee's job, and that no work is performed during the attendance at the training. So really what this comes down to is, let's look at the hours that the employee is attending the training and whether it's voluntary. Voluntary is the most significantly litigated portion of this regulation. If you at any time tell your employee that they must attend this training for purposes of their job, then it is going to be paid, whether it's outside of working hours on a Saturday, a Sunday, or in another town, for example. What isn't going to be paid is if it's voluntary. So let's take a scenario where you have a job position called Customer Service Rep 1. And in order to be Customer Service Rep 2, the individual must complete certain training, certain courses, or whatever additional education that might be necessary. And the employee decides, well, I will go through that course, I will sit down and go through the training, and I will become Customer Service Rep 2. Now, is that voluntary or involuntary? Is that going to be paid or unpaid? The regulations would say that it is involuntary. I'm sorry. The regulations would say that it is voluntary because the employee is trying to better him or herself. Even though it is required for the employee to move up in your organization to take that course, he or she is voluntarily wanting to improve and get a new job. So that would not necessarily be paid. The same would be true in a scenario that an individual would take a college course outside of the employer's hours. And even if it is reimbursed, that doesn't mean that the time spent in the course would be paid time by the employee's standard hourly rate. It is because that is a voluntary course to better improve the individual, not necessarily the benefit of the employer. So those are the types of scenarios where you would not have to pay a person to engage in training time. Okay, so we are in the middle of fall. We're headed out to winter. We're hopefully not going to have too bad of a winter, but our state is quite large and we have very different weather patterns and issues that are associated with the ability of a city to clean roads and get everybody to work or school on time. And so bad weather policies are something that come up each and every year within my practice. So how do we handle bad weather? The question that always comes up is, can an employer make a policy that employees must use their paid time off or be unpaid on a day when bad weather forces the employer to close for the day? When the employer has no choice but to close its doors, what happens and how do we pay our employees? So the non-exempt employees are easy. The regulations state that if the employee doesn't work, the employee doesn't get paid. That means if the employer closes its doors or keeps them open. You show up, you get paid. If you don't, you don't. That's an easy one. The bigger issue is the exempt employees. So as we all know, and one of the issues that we have to deal with is how do we and when are we allowed to dock an exempt employee's pay? Obviously, exempt employees have a lot of different benefits. They are supposed to be paid for all hours worked in a work week when they perform any work. And so what happens when we close our doors? The exempt employees still must be paid as long as they've worked some portion of that week. Now, the employer can and is authorized to deduct from the paid time off bank a day to cover that bad weather closure, which means that that bank is just depleted by a full day or 8 hours, however you keep track of it. But I want you to think very carefully before doing that. If a vacation day or paid time off time is deducted, that obviously depletes the employee's bank. Does that cause a morale issue or a PR issue? Because you've got an employee who would have been paid regardless. If they didn't show up at all that day on their own, they still would have been paid. And so it could cause some morale issues that you would not, deduct from that paid time off bank and you could have a little bit of a disagreement with your employee. If you're going to do that, if that is going to be your policy, I would highly recommend that be put in your employee manual, or that you notify your employees when you're closed for bad weather that this is how you will be paid or how your compensation will be affected, because communication, I think, is the key to everything. Obviously, in this scenario, if the employee, the exempt employee, didn't have any paid time off days left in his or her bank, you still would not be able to dock the employee's pay that day for not showing up to work. Obviously, because you're closed, but you'd have to pay him or her for the full week. And so you'd have to be really careful about disciplinary issues with regard to that as well, because it was your choice to close for the day. Okay, so this is our final area, and then at the end we'll have time for questions if anyone has any. Probably should have said that at the beginning, but I did not. This is our final area, and hopefully we'll get through not only in time to answer questions, but perhaps time to get you to an early lunch. This is running out of leave is our last nightmare scenario, and it's a situation that is fairly common. I think leave scenarios are complicated, and I think they cause a lot of heartburn for sure. So one of the things that we're going to talk about today, or the thing we're going to focus on today, is running out of leave. Now, we can talk about the Family Medical Leave Act, we can talk about the ADA for an entire day, and that is not what we're intending to do today. We're going to focus on this very narrow issue. And so the first scenario is, what happens when any employee who takes leave under the Family Medical Leave Act but doesn't come back to work? Is there a difference between an exempt employee and a non-exempt employee? What happens if an employee needs time off but is not covered by the FMLA? What can we do? So I'm going to take that one first. If the employee is not covered by the FMLA, do not offer FMLA leave. And that is a scenario where either you do not have the 50 employees necessary to trigger your obligation to provide FMLA, or a situation where the employee has not worked for that 1 year and 1,250 hours to qualify for leave. If you offer it in either of those scenarios, you will be required to follow it. If you mess it up, you are going to be obligated under the law. You will not have a defense that, oh wait, we weren't subject to the FMLA, so even though we messed it up, we're not going to be liable. In this circuit, and this federal circuit that covers the state of Kentucky, if you offer FMLA leave, then you must abide by all of the rules. So let's talk about leave. The leave is simple in some ways. The leave provides 12 weeks in a 12-month period, and that is not very different from the ADA. The FMLA leave is offered to employees who have a serious medical condition or are caring for an individual with a serious medical condition, and they are entitled to be completely relieved of duty for the period of time that they are restricted. And that could be on an intermittent basis, where it might be every other, 1 day a month, 1 day a week, or they can only work so many days per week. The ADA, on the other hand, provides that certainly leave could be a reasonable accommodation, but there could also be a scenario if you're on ADA restrictions where you would be working. You might work different hours, you might work in a different job so that you can perform your duties. If you had lifting restrictions, maybe those restrictions might be accommodated. And so you can, under the ADA, perform duties. And so those are the two different leaves. While they both will provide job protection, the FMLA does not require reasonable accommodation. It just requires that you are entitled to the leave and that your job will be protected when you come back. So under what scenarios can we have deductions from pay? So when we talk about exempt employees, if you have an exempt employee who is on intermittent leave, obviously if they're on consecutive leave, they're gone for a week, they're not paid if they perform no duties within a week. But if you've got an exempt employee on FMLA leave that is intermittent, how are we going to pay that person? Because, excuse me. Sorry, we just had a little, okay. If your exempt employee is on intermittent leave, then you're going to have that individual who might work 2 or 3 or 4 days a week, but not a full 5. And as we know from our regulations, our exempt employees are entitled to be paid for a full week when they work any part of the week. There is an exception for FMLA. So if the employee is taking FMLA leave, the law allows for the employers to deduct that partial or full day absence from the exempt employee's pay. This is one of the very limited scenarios where you can take a deduction in pay from an exempt employee's paycheck. Now, you're going to have to correctly determine the hourly rate to determine how much money you will deduct from that exempt employee's pay. And that's, again, for another day or another seminar. But that is a perfectly legitimate way to deduct from an exempt employee's pay. Now, we would want to make sure that we have the proper documents for the exempt employee to be on FMLA leave, because we want to make sure that if we're taking a deduction and that is somehow audited, whether it be through an investigation of the Department of Labor or through litigation, that we can show that this person was actually on FMLA leave. We're going to want to explain and communicate with the employee that we are going to deduct for your partial or full day absences because the law allows us to, and explain that to the employee so that when there is a deduction in his or her pay, they will know that it is not a mistake. Obviously, they can use paid time off to cover those, and the employer can deduct from the paid time off bank those hours to cover the partial or full day absence. But again, we want to make sure the employee knows that those hours will be deducted from the bank. Now, what happens when the employee doesn't return or the FMLA leave expires and they are not returning to full duty? In your non-exempt employee, that individual is out of your FMLA leave. The 12 weeks are up, whether it's intermittent or not, and they are not back to work full time or full duty. The first question is, do we have an ADA requirement? Does the ADA require us to extend this intermittent leave to allow for a disability? So if, for example, the individual is continuing with treatments for cancer and that is covered by the ADA, then you are going to probably have to extend the FMLA leave on an intermittent basis, and we'll call it ADA leave, as a reasonable accommodation to allow the individual to finish up his or her cancer treatments so that they can return to full duty. Obviously, the time they're away from the office as a non-exempt employee would be unpaid. Now, what about your exempt employee? We have an exempt employee who has depleted his or her FMLA leave. It's the same scenario. They need additional time for the for provision of cancer treatments. How do we compensate that individual in that scenario? We have an individual who has depleted his or her PTO bank. There is no way to cover for that partial or full day absence. But as a reasonable accommodation, if we have to extend the leave and there's no more FMLA, I don't believe you can deduct any portion of the individual's pay for those days that he will be or she will be in. My example would be the cancer treatments. I think the FMLA, having been expired, doesn't protect you to deduct those hours. At that point, you have to determine whether the accommodation of extending that intermittent absence is going to be reasonable, whether it creates an undue hardship for you, whether it qualifies as ADA leave, in order to determine how we're going to move forward with that particular employee. But the purpose of this seminar is to discuss whether that's compensable time. I think the exempt employee, while under FMLA leave, you have a reason, you have a law that allows you to make that deduction. But once they're out of FMLA leave, or if FMLA is not covered, then you are not allowed to take that partial or full day deduction, and you're going to have to pay the exempt employee for the full week, even in a work week where they don't perform work on each and every day. I may have covered this. What if my ill employee is covered by the FMLA and the illness is not a disability under the ADA? So if the if the ill employee is not covered by the FMLA and the illness is also not a disability, under that scenario, the employee doesn't really have any rights. You cannot dock the exempt employees' pay. You will have to determine whether you will provide them leave, but I would be very careful about providing leave that is otherwise not required by law, to make sure that you're not discriminating against another individual. Once an individual under any scenario, whether they come off FMLA leave or otherwise, if they cannot return to work and they cannot meet your reasonable job expectations, and one of those being attendance, then you are free to terminate the employee who is not protected by the rules or who is unable to return to work. That is a scenario that I certainly advise you to do a little digging, a little research, perhaps consult with counsel, because it is always a very tricky situation to terminate an employee after the end of a leave. I think that it raises red flags. I think it can be done in an appropriate way, but it also can lead you to a bad scenario if it's not done appropriately. And so we want to make sure the communication is covered and that we are setting up our best defense for a claim that we violated the FMLA or the ADA in the way we communicate with our employees. And so, as a final reminder, all employees, whether they're covered by FMLA, ADA, or any other rules or laws, are always, always, always expected to meet your reasonable expectations. And so those are the types of things that we focus on when we are deciding to take some sort of employment action against someone who has taken leave or who has exceeded their leave. So I hope that today you have taken away some different ideas or policy changes so that you can adopt or change those for the upcoming year. Want to emphasize that I think today's seminar, it focused on communication with the employee, because these rules are not necessarily known by the employee and they affect their pay. And that is one sure way to get an employee angry, is to affect their pay without them knowing. So there are lots of different homework assignments, including reviewing your job descriptions and determining, if you have an issue with telecommuting or you want to institute a telecommuting policy, make sure you have the appropriate documentation for that, as well as all of the compensation issues that we've discussed today. And so I am ending a little early, which is always my tendency. And if there are any questions, we'll leave it open for the next few minutes. Otherwise, we appreciate your time and attendance. And as always, if there's anything we can ever do to help you, please don't forget to reach out to any one of us. Okay. All right, we have no questions, so we're going to go ahead and get off and let you guys get to lunch and get on with your Halloween festivities. Thank you.